It's 5 o'clock, so time to get started. Hello, everyone. Thank you so much for joining us. I'm hoping you've been able to make the most of the intermittent sunshine we've had this summer, including today. Looks like we've been very lucky. But if, like us, you're based in the north of England, I hope for the rest of summer you've been able to keep warm and dry. So on behalf of the Office of Philanthropic Partnerships and Alumni and local solicitors Crombie Wilkinson, it's an absolute pleasure to welcome so many friends, staff and alumni to this evening's YuPlan session. As an introduction, my name's Laura Higton. I'm the Donor Experience Officer at the University of York. And alongside Marisa Bailey, who's our legacy officer, we offer information and assistance to anyone that's considering leaving a gift to the University of York in their will. So gifts and wills provide the university with vital support, and the generosity of those who acknowledge the university in their will allows us to achieve some really incredible things. So, for example, off the top of my head, we've got funding directed towards generation research, which offers life-changing technical research studentships to the next generation of scientists. Then we've got gifts left to the York Sanctuary Fund, which support academics displaced by, say, conflict or civil unrest. And we've also got the newly launched University of Opportunity, which aims to widen access, participation, attainment and progression by providing flexible funding opportunities to those who need it most. And then, of course, we've got all the wonderful legacy gifts that fund scholarships, prizes, research, and allow us to expand our ever-growing library and archives. So if you'd like to discuss leaving a legacy gift, or you're interested in finding out more, or perhaps have any questions, then please do get in touch with myself or Marisa after this session. So Marisa and I are also responsible for planning this free event in collaboration with Crombie Wilkinson. And speaking of which, I'm delighted to welcome our speakers today. We've got Richard Watson, practicing solicitor and former senior director and head of the private client team. And we've got Belinda Poulter, director at Crombie Wilkinson. So Richard and Belinda have very kindly volunteered to join us this evening. And I just want to take this opportunity to thank them both for their participation and also their expertise. Before we start, just a little bit of housekeeping. This session is being recorded, but throughout the presentation, your video will automatically be switched off and your microphone muted. So currently we can't actually see or hear you, but it's lovely to have you all here. The talk will last for around an hour, after which there's going to be plenty of time for a Q&A session with Richard and Belinda. So if you have any questions, type them into the Q&A box, which can be found towards the bottom right of your screen. That is separate, might I highlight, to the chat option, which will be disabled for the duration of this talk. If you can specify whether your question's directed for either Belinda or Richard, that'd be really helpful. And then Marisa will then read them out for you once the presentations have concluded. So, now the formalities are out of the way, I'm delighted to hand over to our first speaker, Richard Watson. Richard, over to you.
Well, thank you very much indeed. Just to put something slight on the record, I am in fact now retired as a solicitor, but I'm still actively involved in this sort of matter. One thing we did want to touch on just before we began is that we have learned this week at the university of the very sad death of David Foster. David was academic registrar at the university for very many years, and I'm perfectly sure that a number of people who are joining us this evening will remember him at the university. He was a devoted servant of the university, and in retirement took an active interest and participation in it. He also was part of what we jokingly called the York Network. York is a big village, and he played a very large part in that. So I know he'll be very sadly missed by all who knew him. Okay, today we're going to start by talking about wills. And the fundamental question, which everybody has to ask, is why make a will? Well, the first reason for making a will is that you can choose the people or the persons or the institutions to which you want to leave your property, your money, your assets. If you don't make a will, you are said to die intestate, and the law dictates who inherits. That which is dictated by the law might not be what you want to happen. Later on, I'm going to talk a bit more about intestacy, but the first reason for doing a will is because it does allow you to choose to whom your property is going. The second reason, and this is very much a question of practicality, is that the people who you appoint as your executors have immediate authority to act. The will gives executors the power to act straight away. Now, for dealing with significant assets in an estate, further down the line, the executors are going to have to apply for something called a grant of probate, and that is confirmation in terms of the validity of the will and the authority for the executor to act. But in many instances, the mere fact that an executor is appointed within the will allow them to have access to bank accounts, building society accounts, and the like, and also to get on with organising the day-to-day things which have to be arranged after somebody has died. Beyond that, there are more subtle, if you like, reasons for having a will. First, we can look about the efficiency from a tax point of view. We'll be talking about inheritance tax later on, but broadly speaking, so much of your estate will be deemed to be tax-free, what's called the nil rate band. After that, inheritance tax is payable. You can actually arrange your affairs so as to mitigate not only inheritance tax, but other taxes as well. So, for instance, if you create a life interest trust into which you put bricks and mortar type property, it might be a very good way of avoiding capital gains tax. Capital gains tax is one of those rather strange taxes, but if you're caught out by it, it can leave you with a very large tax bill. Looking at the younger end of the equation, the law will automatically say that when a child reaches 18, they are capable of inheriting. And that will certainly apply under the law of intestacy. Under the age of 18, money is held in trust for youngsters. Dare I call them children when they get to 17. Sometimes people feel that 18 is far too young for somebody to inherit money, certainly to inherit a lot of money. A bit depends on the individual, certainly. A will gives you the opportunity of saying that whilst the youngster can have the income at a younger age, the actual capital sum is not something that they can have till an older age, typically 21, 25. Excuse me, I once in fact did a will where the person wanted, and the person concerned was a solicitor as well, didn't want the child to inherit till they were 55, but I did talk her out of that. So, executors and trustees. As I said earlier, the executor or the executors are the people who step into your shoes once you have died and are instructed to carry out what the will says. It might be the situation that there's an ongoing trust, that is to say that money assets have to be managed for the benefit of somebody else. And it's typical that executors become certainly the first trustees, if that is the case. It might be the situation they stand down a little while down the line and other people are appointed. And if there's something special in the estate, it might be that you have different people as trustees. Say, for instance, if somebody were a writer and they had literary rights, it might be that you had specialist people handling that aspect of the estate. But usually, it is people who are either family members, typically from the younger generation, because of course, statistically speaking, they're going to outlive us. Or it might be close friends, or it might be the situation of choosing a professional, such as a solicitor. Solicitors tend to be chosen, A, if there is nobody about to step into the shoes, or perhaps when it is feared that there might be a little bit of a dispute amongst family members, and to have somebody independent just able to sort the thing out with a skill base and not to be emotionally involved can be very useful. We're sometimes asked about what about children as executors when they haven't reached the age of 18. And it's perfectly possible for you to write into a will that a child who, at the time of executing the will, is not 18, that when they reach the age of 18, they are appointed as an executor. Now, in terms of the types of legacies, the first type of legacy to talk about is the gift of something specific, the specific gift. So, for instance, you have a very nice watch, you have jewellery, you have some fine furniture, you have stocks and shares. You might be quite specific. I give to my spouse all my shares in Shell. I give to my son my very nice watch, etc. We then have pecuniary gifts, gifts of money, specific amounts of money. I give £100 to somebody. I give £1,000 to the university, which has done so much for me over the past, and the like. And it's also at that point you might very well provide a gift for a charity. We'll talk about it a little more later on, but gifts to charities are very tax efficient. So if your estate is liable to inheritance tax, giving to a charity is something very well worth considering. What is left is said to be the residuary estate, and whilst the specific gifts are certain from the time you write your will, you're never quite going to know what your residuary estate is going to be, because by definition, what you have varies on a day-to-day basis. You spend money, you receive income, etc. So residuary gifts, frequently they're reflected in percentages or fractions. Whilst it might be quite common to say you give everything to a spouse or a civil partner, after that you might say, I give everything to the children, and if more than one in equal shares, or I give a certain percentage to relatives, certain percentage to a friend, a certain percentage to charity. The final thing I want to touch on is a will's an ideal opportunity if you want to give simple instructions in terms of the type of funeral you would wish. It might be whether you wish your remains to be buried or cremated. It might be whether you wished for a particular religious service, or it might be you wish a secular service. Short, simple directions in the will always help the executors or whoever is arranging your funeral. If you do want to go into some more detail, it's probably as well for you to write that out separately. Good idea to let your executors know in advance that you've done that note, and possibly just make a reference in the will that you'd wish your funeral to be conducted in accordance with any letter of wish which you leave with your wills or your private papers. So that's a very quick run through under that heading, why make a will? I've touched on the issue of trusts in a will. They are used very extensively, frequently, without people realizing they are being used. But Belinda's going to talk now in a little more detail as to how you can use trusts for your own advantage. So over to Belinda.
Thank you, Richard, and good afternoon, everybody. So Richard has given us a good overview of the main components of a will and why it's really important to make a will. The type of will that Richard is talking about in particular is a will where someone's estate is fairly straightforward. They know exactly who they want to leave their assets to, and there's no complications on the horizon. Unfortunately, many of our lives aren't like that, and we have other difficulties we may need to consider when we're thinking about to whom we want to leave our estate. And that's where trusts can come in useful. Now, trusts on the surface can seem extremely complicated, and people look at them and think, oh, I don't want that. My beneficiaries or my executors, won't be able to deal with this. But actually, there are many different types of trusts. Richard touched very briefly on leaving monies to a child who is maybe very young and extending the age at which they can inherit to 21. Well, that's a very simple trust, and that money is held on trust until that child's 21. And all that really means is that someone else is looking after that money for that person. It's not their money, it belongs to the person, but they can't actually have that money themselves until they reach that age. But there are other types of trusts that you can include in your will, and in fact we do include them in wills fairly often because they provide an extra dimension to how you want your estate to be left, depending on the people you want to leave it to. So I'm going to touch on the different types of trusts. There are two main types. So the first type of trust is known as a life interest trust, and effectively it does what it says on the tin. You have a life tenant who is given the use of those assets either for the rest of their life or until a particular terminating event is reached, and then that trust would end. Alongside the life tenant, there is what's known as a remainder beneficiary. So the remainder beneficiary is the person who then benefits from those assets once the life tenant has either passed away or the terminating event has occurred. Sometimes that terminating event is that somebody has remarried, or that somebody has passed away, or that maybe they've, if we're talking about a property, maybe they've left that property permanently. So life interest trusts are a relatively simple trust that you can set up in your will. In particular, life interest trusts are very appealing to people who are looking at their assets and looking at their futures and wondering if there's a way to preserve some of those assets from all being used up to pay for residential care in the future. Many people come and ask the question, can I give my house to my children so it won't be used for my residential care? And generally our answer is no, not really. But here's a way we think you can preserve some of those assets. So let's, for example, take your property. If you own your property, a husband and wife or civil partners, and you both own your property jointly, you could leave your share of the property into a life interest trust on the first one of you to pass away. The life interest trust would name your surviving spouse or civil partner as the life tenant, and then you would name your remainder beneficiaries. This ensures that the survivor can remain living in the property for the rest of their life, or as I mentioned before, perhaps if they moved into permanent residential care. They would have the use of that property undisturbed. This means that if the survivor, for example, had to move into a care home, then although their share of the property may be used to pay those fees, the half share that's passed into the life interest trust is preserved for the remainder beneficiaries. It's a flexible type of trust, which means that if that person needs to downsize and move into a smaller property, all of the assets in the trust are available to purchase a new property, not just the half that that person already owns. So it's flexible in that it can move to another property. It's flexible in that if the property was sold completely, those assets could be invested and an income could be provided for the survivor. It gives people the opportunity to be happy that they have preserved something for their future beneficiaries, but while still allowing their surviving spouse or civil partner to be able to use that asset while they're still alive. One thing to note if you are thinking about putting a property into a life interest trust is there are two ways of owning property. If you own a property jointly with another person, you can either own it as joint tenants or tenants in common. If you own your property as joint tenants, then when one of you passes away, the property automatically passes to the ownership of the surviving joint owner. If you wish to include a life interest trust in your will, you would need to sever that joint tenancy so that you own the property as tenants in common. Tenancy in common is also used if you purchase a property with somebody, but one of you has maybe put in more money and they own a greater share of that property. Those people would own their property as tenants in common. But if the property is owned equally, it may be that you own as joint tenants. This can easily be rectified by a severance of the tenancy. It's a very good way of including in your will a way to preserve some of your assets for your future beneficiaries when you don't know what the future holds for you. Another really good reason for the use of a life interest trust in your will is for people who are on second marriages. Maybe you both have children from your first marriage and you are wanting to make sure that those children will receive some of your assets whilst not disadvantaging your spouse or civil partner. Again, the use of a life interest trust can mean that if you pass away first, some of your assets can pass into the life interest trust. Your spouse and civil partner then can have the use of those assets for the rest of their life, but you can be happy that those assets that have gone into the life interest trust will pass to your own children. Nobody wants to think that you can't trust the person that you've just married, and nobody wants to think like that. But you do need to think that any will can be changed once you've passed away. So if you made a will that left everything to your surviving spouse or civil partner, in the future they could change that will and potentially leave all their assets to their own children or to somebody completely different. It offers a bit of peace of mind that you know that whilst you're not disadvantaging your spouse or civil partner, you can make sure that some of your assets pass to your own children or your own beneficiaries. I've talked in particular about life interest trusts using a property, and that is the most common way that we use life interest trusts in your will. But you can also use other assets in a life interest trust. You can put in investments that may create an income for your spouse or civil partner during their lifetime, but the actual capital value of those assets can pass elsewhere. So they do potentially provide that flexibility for somebody, but also give them the peace of mind that some assets will be preserved for your beneficiaries, depending on what life throws at you in the future. The second type of trust that we commonly use in a will is a discretionary trust. A discretionary trust is a trust where the trustees, your executors who usually become the trustees of the trust, have absolute discretion as to where those assets are distributed to. A discretionary trust can be a very useful way of making sure your assets are distributed how you want them to be distributed. You may not actually be sure at the time that you prepare the will how you want those assets to be distributed because life may change, life moves on. The discretionary trust gives your trustees, the people you trust, the discretion to make those decisions after you've passed away, as to where would be the best place to distribute the assets at that time. In your will, you would dictate who the beneficiaries are. You would name a group of beneficiaries that are all potential beneficiaries of those assets. There are certain circumstances in people's lives where a discretionary trust can be extremely useful. For example, you may have children who are suffering from a form of disability. That disability might mean that they're not able to manage money under their own right, but you want to make sure that they can be looked after and that monies are available for them. You know that if you give them a large sum of money in your will, that they won't be able to manage it, which can potentially make them very vulnerable. A discretionary trust is a really good tool to use in your will to allow those monies to be placed in a trust. They're then managed by other people, but those people will know that the disabled child, the disabled beneficiary, is the person who should be the person who benefits from those assets. You may have children who have other mental health difficulties, children who may have addictions, who again, you don't want to leave a large sum of money to. That money then could be drip fed to them as and when they need it and for things they need, rather than having a large sum of money, which again would make them very vulnerable. Your trustees would know all of this. They would be people who are sympathetic to what you want to happen with the monies in the trust. You don't want to miss those beneficiaries out, but you need to make sure that those monies are managed for them. One aspect of a discretionary trust is that if your beneficiaries or any of your beneficiaries are receiving any means tested benefits, monies held in the discretionary trust are not classed as belonging to that beneficiary. So if you have, for example, a child with a disability who receives some benefits and maybe some means tested benefits or benefits that provide them with accommodation, they can maybe manage that amount of money that comes in, £100 and something a week. They can maybe use that to buy their own food and pay for their household bills, but a large sum of money would stop those benefits coming in and they would have to learn to manage that. The monies that are in the discretionary trust would not affect their means tested benefits because those monies are not classed as theirs. The monies are held in the trust and the trustees can use them for things that those benefits may require going forward, but not as part of their regular income. You may have children who have businesses and those businesses may not be necessarily doing so well. You wouldn't want a child to inherit a share of your estate if that money was likely to end up with a trustee in bankruptcy. That money could be held in the discretionary trust. That money can be used for their family's benefit. And only when the bankruptcy term has ended, that child could receive the money that's there. The same with a divorce. You have a child who's going through a divorce. You wouldn't want that money to fall into their lap just at the time when their financial circumstances are being agreed through the courts. That money can be held in the discretionary trust, and then once all of that is over and agreed, that money could be made available to that child. You may have children that have a lot of wealth of their own, and actually they don't need their inheritance. You wouldn't want to just miss them out of their will because many parents wouldn't want to do that with their children. By placing the money into the discretionary trust, your children can tell the trustees that they don't want payments from that money. They would rather that money was passed to their children, perhaps. And the trust has the flexibility to do that, provided that you have included a wide range of beneficiaries in a discretionary trust. Those beneficiaries can benefit, and it is at the trustees' choosing. Now, you may say to me, well, I'm not sure my trustees will choose the right people to distribute that money to. If we prepare a discretionary trust for you, we would also prepare a letter of wishes. A letter of wishes is your opportunity to speak to the trustees, to tell them why you've set up the trust and to tell them how you would wish the assets in the trust to be used. The trustees would always have the discretion to look at these circumstances at the time and decide whether what you've said is reasonable or whether money should be advanced to those beneficiaries. But it is your opportunity to say, I've set up this trust and actually this is what the trust is for and this is what I would want you to. If you've chosen your trustees wisely, you should be confident that they will administer the trust and give money to the beneficiaries as you would want them to, given the circumstances are right at the time. There's another type of discretionary trust that we don't use so often nowadays, and I'll touch on why. It's to do with inheritance tax and some of the exemptions from inheritance tax, but it's called a nil rate band discretionary trust. The purpose of a nil rate band discretionary trust is that you can put assets up to the nil rate band into this type of trust. It allows the flexibility that you can still say that the surviving spouse or civil partner is one of the main beneficiaries of that trust, but it helps to preserve those assets. As I mentioned before, second marriages, it can help to preserve the capital value or some of those assets for your beneficiaries while still allowing the surviving spouse use. It gives a bit more flexibility with those assets. And in particular, if you have assets that are likely to increase in value, if you passed those assets to a surviving spouse or civil partner, that would swell their estate. And if they're an asset that may increase in value quite quickly, that may mean that on the second of you to die, that estate becomes inheritance taxable. If those assets are put into the nil rate band discretionary trust, the value of those assets can increase within the trust and not in the estate of the survivor. So when you're considering your estate and the assets you have and when you want to leave them, trusts can be a very, very useful way of making sure that your assets go to the beneficiaries that you wish them to go to, but in a manner that works with their particular circumstances at the time. You can also make and prepare trusts during your lifetime. They don't have to be within a will, but many people will look at their will as an opportunity to place assets into a trust at that time. Whereas with a lifetime trust, which many people do make, but a lifetime trust means you lose the right to use those assets once you've placed it into a trust. With a will trust, you can use those assets right up until your death, and then the assets are moved forward into a trust. The trust is not set up until one of you passes away. I think Richard's going to talk to you a little bit more about intestacy and what happens if you die without leaving a will.
Right, yes, thank you, Belinda. Well, we touched on it, intestacy at the top, and the first thing to take into account is that if you die intestate, nobody has power to do anything until a grant is issued. I talked about a grant of probate, which is the authority from the court for you to handle the estate of somebody where there is a will. Well, in a intestacy, the grant is called a letters of administration, but to all intents and purposes, it does the same thing. But in reality, you're going to need that grant before you can do very much in the estate of somebody who dies without a will. Even if you are able to get on top of things very early on, it is going to take a matter of months before you get the grant. Typically, once you have submitted an application, the time you have to wait for the court to respond is measured in months. It's distressing for people, it's inconvenient for people. The Inheritance under an intestacy is dictated by Act of Parliament, an Act of Parliament which appreciably, having been updated on a number of occasions, is now coming up to be 100 years old. And it has a very strict order of priority in terms of who can inherit. First and foremost, you look at the spouse or the civil partner, and if there are no children, then the spouse or the civil partner will inherit everything. For the spouse and civil partner, where you have children, the calculation is slightly more complicated. First and foremost, the survivor gets the personal possessions and what is called the statutory legacy, and that is an amount of money or items of value that is currently £322,000. It was last revised in 2020. They also get a half of what is left, and the other half of what is left go to the children. If there's more than one child, then the children take equally. If it's a situation a child has died leaving children, that's to say your grandchildren, then your grandchildren will inherit the share which their deceased parent would have taken. It's what's called the statutory trusts. Belinda touched on joint tenancies and tenancies in common. Primarily, they relate to property. Normally, you're talking about the house in which you're living. If you are a joint tenant, it means automatically your spouse will inherit on your death. If it's a tenancy in common, it will follow the rules of intestacy in the case of a situation where there is no will. That means, therefore, there is probably a colossal difference as to the destination of assets, depending on whether or not there is a joint tenancy or a tenancy in common. If there is no spouse or children, there is an order in which close relatives take, and broadly speaking, they are grandparents and the issue of grandparents. So you talk about parents, uncles, and aunts. If there is nobody in that class, then the estate is said to be bona vacantia. That's to say that we're talking about ownerless property, and it vests in the Crown. In reality, it goes to the Treasury. That said, the Crown is able to look around and look at people who might have a good claim. It is, though, a very difficult situation at the best of times. The intestacy position is particularly dangerous when a couple are unmarried but have a family, because the unmarried partner of the person who has died has no claim under the law of intestacy. There is a remedy for that person, and that is under the Inheritance Provision for Family and Dependents Act 1975. And that means that people can apply to the court where they believe a will or an intestacy has not made proper provision for them. And put very simply, in the case of a spouse, the court should make an order for a sum which is reasonable. In the case of other relatives, other dependents, and cohabitees of at least 2 years, then the court should provide for reasonable maintenance, which is a different criteria than a reasonable sum, particularly if you're talking about a fairly wealthy person. It can therefore pitch a parent against children, because children, in the case of the unmarried couple, are likely to inherit the entirety of the estate, whereas the unmarried partner gets absolutely nothing. It's a very unsatisfactory situation. And I think in terms of the order of priority of things, what I do urge is that anybody who is in that situation does very seriously get around to making a will very quickly. When I was practicing, I did a lot of contentious probate work, and the unmarried partner scenario, which I've just talked about, was frequently one of those scenarios which involved litigation. And it's litigation at a time when people obviously are upset and nerves are very raw. So that's a fairly quick gallop around the law of intestacy. So back to Belinda, the two certainties of life, in the words of, I think it was Franklin, wasn't it, are death and taxation, and Belinda's going to talk about inheritance tax and what it's all about.
Nobody wants to pay tax, I get that. Inheritance tax is a tax that's paid on your assets on your death. Nobody wants to pay that either. I had a little look before we came to this seminar, and for the year 2023 to 2024, inheritance tax receipts were 7.5 billion, which is up 400 million from the year before. That's a lot of inheritance tax. And predominantly because people's wealth is increasing, because the value of property is increasing, and maybe people aren't doing what they need to do to try to minimise their inheritance tax liability. Inheritance tax is taxed on all of us, but there are various exemptions which we can apply to an estate on somebody's death. Each of us have a nil rate band of 325,000. This means that we can pass £325,000 worth of assets to any beneficiary. That first 325,000 is taxed at 0%. So there's no tax to pay on those assets. Any assets that you pass above that amount is taxed at 40%. With the qualifier that all assets that pass to your surviving spouse or civil partner is not taxable for inheritance tax. You can now pass your nil rate band to your surviving spouse or civil partner. So, for example, you pass away and leave all of your estate to your surviving spouse or civil partner. They take all of your joint assets, the assets they own and the assets that you own. You also pass them your nil rate band of 325,000. So when they pass away, they now can pass 650,000 to what are classed as non-exempt beneficiaries. So your spouse is an exempt beneficiary. So non-exempt beneficiaries would be your children, your grandchildren, other relatives, or other beneficiaries. So anybody with assets over 650,000, if they've used their transferable nil rate band, then have the potential of inheritance tax being payable. And as I said, that's at 40% of assets over that value. However, since 2018, we have had the introduction of a residence nil rate band. The residence nil rate band is on top of your nil rate band, but applies specifically to passing a residence, so the property that you have lived in until your death, to your direct descendants. There is listed a list of who your direct descendants are, but essentially they are your children, your grandchildren, moving down that list. Direct descendants does include your spouse. So again, assets, your residence passes to your surviving spouse, then again, you qualify for the residence nil rate band. The residence nil rate band is currently at 175,000. So for a lot of people, that's not the value of their house, and that may be not the value of half of their house. What you always need to bear in mind, however, is that it only can be used against a property, a residential property. If, for example, your share of a residential property is less than 175,000, then you can only claim the value of that property. The residence nil rate band, as I've said, is also transferable. So if your property passes to your surviving spouse or civil partner, so does your residence nil rate band. So essentially, you have an inheritance tax nil rate band of 325,000 and potentially a residence nil rate band of 175,000, which, if all the circumstances are right, means you can pass assets up to 500,000 on your death. If those assets pass to your surviving spouse or civil partner, you can transfer both of those exemptions to them. So on their death, they potentially can pass assets up to £1 million without any inheritance tax being payable. There are various qualifications on that. If you pass some assets to a non-exempt beneficiary, for example, your children, you give them a sum of money and the remainder of your assets pass to your surviving spouse or civil partner, then your inheritance tax is reduced by a percentage that those assets bear to your total estate. But you can still claim the difference. One thing to note, that in terms of the residence nil rate band, if you don't have children, but you have stepchildren because you are married to their parent, then the residence nil rate band will still apply on your residence passing to those children. The residence nil rate band will also apply if your child has died before you and that share of the property passes to their surviving spouse. So it includes spouses of your children who have died, and it also includes your stepchildren, provided that you were married to their parent or had a civil partnership with their parent. So for many people, those exemptions mean that their estate may not be taxable to inheritance tax. One thing to note in particular, and Richard touched on this when he talked about intestacy, is the difference between being married to somebody and non-married. If you are married or have a civil partnership, then the nil rate band and the residence nil rate band can transfer to your surviving spouse or civil partner. If you are not married, then there is no use of the transferable nil rate band or the transferable residence nil rate band. So if you are unmarried and your partner has children, then you cannot leave anything to those children and it qualify for the residence nil rate band. In an intestacy, again, they won't pass to your partner that's not your spouse or your civil partner. So it's something to bear in mind when you are thinking about your will and when you are thinking about your assets. Always look at the exemptions that are available, but just think carefully about the potential where those assets, those exemptions won't be available to your estate, perhaps because you are an unmarried couple and there are children, but they're not the children of both of you. None of us want to tell anyone that they should get married, but when you are looking at inheritance tax planning, sometimes it is the only way to go to ensure that the exemptions pass where you want them to. One thing to note, I talked about the life interest trust, and in particular a life interest trust where your spouse or civil partner is the life tenant. If that's the case and you include that in your will, then both the nil rate band and the residence nil rate band are treated as if those assets have passed to your surviving spouse or civil partner. So the inheritance tax position, if you've included a life interest trust to your spouse or civil partner, is as I have described it for assets passing from one spouse to another. That's a bit of an overview of inheritance tax. There are other things to look in mind. There are other exemptions which Richard is going to touch on shortly. One other thing to note is that you can gift things to a beneficiary. If you survive 7 years from making that gift, the value of that gift will fall out of your estate for inheritance tax. So if I make a large gift to somebody today and I survive more than 7 years, the value of that gift does not need to be included in my estate. However, if I gift something to somebody, an amount of money, and I only survive 2 years after the date of making that gift then becomes taxable. The actual gift isn't taxable, but what it does is take a chunk off your nil rate band. So I've gifted 50,000 to Richard, and then sadly I pass away a year later. My nil rate band is then no longer 325,000. My nil rate band is 275,000. That then may have an impact on the gifts that pass to my eventual beneficiaries, because they may then have to pay tax against my estate, which they wouldn't have done if I'd made that gift. The beneficiary of that gift doesn't have any tax to pay because all it's done is eaten up a chunk of your nil rate band. So gifting is extremely useful and it's a really good tool to use, but you always need to bear in mind the 7-year rule for assets falling out of your estate. Richard's going to talk to you now further about other ways of gifting and giving which can help your estates from an inheritance tax point of view.
Okay, yes, thanks very much. There's a number of ways in which inheritance tax can be avoided if that is what you want to do. And if we go through something of a list. First and foremost, everybody has an annual exemption of £3,000. So for a couple, that's £6,000. And if you haven't used last year's allowance, you can bring it forward to this year's as well. It's a good way for the wealthy to pass on money to family members, to friends. And over a period of time, it does allow you to dispose of a large amount of money without, or rather with, the advantage that the inheritance tax is saved. There is also a small gift allowance of £250. You can't, by the way, overlap that with the 3,000 so far as the same people are concerned. And in essence, you can give as many gifts up to £250 away without then going into what we call the 7-year cycle. On marriage, there is a fairly generous allowance. On the marriage of a child, you can give £5,000. A marriage of a grandchild, £2,500. Or a great-grandchild, £2,500, and for anybody else, up to £1,000. Again, it's a way of passing over money to the family or to close friends, such as, say, godchildren. Gifts out of income. This is something with a bit of a historical backdrop. When the forerunner of inheritance tax was introduced, something called capital transfer tax, we still lived in an era where adult children, might be assisting with the maintenance of parents. That sort of thing doesn't tend to happen these days, because to some extent we've had a little bit of role reversal so far as wealth is concerned in our society. But the golden rules are these. Gifts out of income. It has to be normal expenditure out of income, and you have to demonstrate that it is surplus income. It has to be paid on a regular and repeating basis. That's not to say it has to be paid every month, but a one-off payment is not going to get you over the threshold. There have to be a number of payments and they have to repeat. And it goes without saying that it's very important that you keep very good records. So effectively, you have to keep a record of what your income is and what your expenditure is. And therefore, you can demonstrate that you have a surplus of income, which is being used for that purpose. Keeping records is very important. And just going back to the residential nil rate band, which Belinda was talking about a few minutes ago, if it is the situation that somebody sells up their main residence in order to go into a care home, then that money needs to be carefully recorded as to where it is, because that money will still qualify for the residence nil rate band, irrespective of the fact that the house has since been sold. Charitable giving. Charitable giving is a win-win-win-win situation. If you give to charity during your lifetime, you are exempt from the 7-year rule. It doesn't matter how much you give in your lifetime, it will not be clawed back into your estate for the purposes of inheritance tax. If you give to charity in your will, again, that amount of money is exempt from inheritance tax. And what is more, if you give more than 10% of your estate to charity, the tax rate on your estate is discounted by 10%. So instead of paying 40% inheritance tax, you're paying 36% inheritance tax. And for those people who are in that sort of position, where they have the likelihood of a tax bill, if you like, just throw around some figures and work out just how much charitable giving you can give and how little it actually costs your estate when you take into account the inheritance tax rule. I always tell the tale. I acted for a lovely old gentleman who was very, very anti-taxation. He was, by the time I made his will, I think he had about £3 million in his assets. And he came to see me, and broadly, he left the nil rate band, £325,000 to family. And the rest he left on a discretionary trust, but specifically for registered charities. And having executed the will, he virtually danced down the road, realizing that irrespective of the size of his estate, none of his estate would be subject to inheritance tax. Now, because of very good financial management, the estate, when he came to pass away, was more than double that amount. So a colossal number of charities, both local charities and national charities, benefited hugely from the estate. And I'm afraid to say the Treasury got nothing by way of inheritance tax. Now, for those people who own businesses and business premises, and for those who have agricultural property, there are very generous reliefs. I'm not going to go into detail because it is quite complicated. What I would say, though, if you are planning to avoid inheritance tax and you're in that position of owning business premises or agricultural property, think long and hard in terms of whether or not you want to dispose of those assets, or whether you want to come to some other arrangement, because it is a good way of avoiding inheritance tax. Yeah, a typical situation is that a farmer gives up farming, but hangs on to the farm and contracts it out, the management. It's that sort of thing. There's two other very, very effective tools. One is investment in what's called the AIMS market. The AIMS market is AIMS is an acronym for Alternative Investment Market, and it is small burgeoning companies on the stock market. If you hold shares in AIMS stock and you hold them for 2 years, you get very, very good reliefs. And in fact, I appreciably it was written somewhat tongue-in-cheek, but reading an article the other day, somebody said tax avoidance is simple. You just invest entirely on the AIMS market, and your estate will come out of the taxation arena. By very definition, the AIMS market is a risky market. Something to bear in mind. And the final avoidance, I think, for me to talk to you about is what I call the doctrine of unforeseen consequences. We did see, best part of 10 years ago now, significant reforms in the arena of pensions. And I appreciate a lot of people listening today will be having company or government-style pensions, but increasingly people, of course, have their own personal pensions, be them PPPs, SIPs, or whatever. And also, even those with company pensions will have the facility to transfer into their own pension pot. Pension pots get money straight out of your estate because they're owned by your pension fund. They're not owned by you. They are governed by their own taxation rules, but most significantly is that, broadly speaking, up until the age of 75, if you pass away, there won't be a tax charge. After 75, passing your pension fund to certain people who keep the money invested in pension services, again, there won't be any tax charge. I do want to emphasize neither Belinda nor I are qualified to advise anybody on pensions, but if this sort of thing strikes a chord with you, do talk to your professional pension advisors. I can remember when the rules were changing a few years ago, and we were doing these talks, and I was looking at this and I'm thinking, hang on, what's going on here? You've got a perfect avoidance tool. And very slowly, I'm sorry, I'm being attacked by a spaniel. Very slowly, the penny has dropped. This is actually a very, very significant way by which people can avoid inheritance tax. Two other little matters just to talk on, and that is death in service benefits. Again, they're the sort of thing linked to an employer pension scheme, something like the university pension scheme. It is probably worthwhile to make sure that any death in service benefit is paid not to your estate, but to the destined recipient, spouse, civil partner, children, and the like. Normally, that is the case. I don't think I've ever come across a scheme which pays into the estate. The danger, of course, paying into your estate is that it swells the value of your estate and therefore raises the potential for there to be an inheritance tax charge. The same goes in respect of life insurance policy. Most people in middle life, particularly if they've got a mortgage and a family, they'll have some form of life insurance, probably to pay off the mortgage if they die, probably to provide a sum of money to keep the family going for a period of time. Again, life policies want to be written in trust for the benefit of the family. They don't want to be written so that the money comes back into your estate, and so it swells your estate, raising the potential for inheritance tax. So if you do have life policies, do check that is the case. It used to be the case that life offices invariably wrote them interest. I don't think that is so much the case today, particularly when you're talking about the smaller providers. Okay, we've talked about charitable giving, and I just want to close from my part of this evening with a personal story, and that is when I was comparatively young, an elderly lady left me an appreciable sum of money. And particularly when you're young and you're setting out, that sort of thing is very, very useful indeed. She was a lady. She didn't have any family. And I like to think she probably thought I would put the money to good use. She was born at the turn of the 19th, 20th century into middle-class stock. She trained as a nurse, and she married a bank official. Her husband became a bank manager. The social demands of the day, of course, meant that married women couldn't pursue a career. They had to stay at home. And I think she was sad she'd missed a lot of opportunity in life. She was committed to education, and famously on one occasion she said to me, she said, well, the thing about knowledge is once they have taught it to you, they cannot take it away from you. And they are words which stick and resonate with me. And I made the decision many, many years ago that money, when I die, with all its capital and income growth combined, will go to education, and it will go to be used at the university here in York, and to help train lawyers of the future. Because equally, I'm very committed to the training of lawyers. If we don't have lawyers in this world, then all sorts of horrible things can start happening. Lawyers are there to defend people's rights. So she was called Florence, but she was known as Jo. And so Jo's money will ultimately come to the university to support the training of people for the future. And I would like to think she would approve of that as a decision. Okay, well, that wraps it up on wills, but I think Belinda wants very quickly to talk about lasting powers of attorney and how valuable they are.
When we talk about wills, we always talk about what happens when you pass away. But as more people are living longer and living healthier, the loss of capacity is becoming ever more apparent. If you lose capacity, yes, you may have a will, but it doesn't give your executors any rights to deal with your assets while you're still alive. The way to make sure that the right people are able to manage your financial affairs if you become unable to do so is through the preparation of a lasting power of attorney. And indeed, as a firm and as solicitors that deal with this particular area of law, we believe that lasting powers of attorney are just as important as preparing a will. So lasting powers of attorney are a new type of document. Originally, you were able to prepare an enduring power of attorney. They are one and the same in that enduring powers of attorney appoint people to act on your behalf in respect of your property and financial affairs. If you have an enduring power of attorney, it is still a valid document, and you don't necessarily need to consider lasting powers of attorney, except that when lasting powers of attorney were introduced, there was two types. There was a lasting power of attorney that covered your property and financial affairs, and that is the document that is very similar to the enduring power of attorney. But you can also prepare a lasting power of attorney that covers health and welfare decisions. So it covers decisions such as where you might live in the future, the type of care you might need to receive, but it also covers who would make decisions for you on a medical basis if, again, you were unable to make those decisions. Should you have that particular operation if you're not able to make that decision? If you have advanced dementia, do you really need a large heart operation, or would it be kinder to let you quietly slip away? And on that note, it also specifically states whether you would want your attorneys to make decisions regarding life-sustaining treatment. So with a power of attorney, you are the person choosing the most appropriate person or people to make those decisions for you. In terms of your property and financial affairs, you can appoint attorneys who you know are good at managing money, who you trust will manage that money correctly for you and to make sure that your money is managed well. For the health and welfare power of attorney, you may choose different people because they are the people that understand your views on various medical treatments, that understand that maybe you don't want to move into a care home, but you would rather receive care at home. They may be the same people because they do overlap. For example, if you are moving into residential care, your health and welfare attorneys are the people that would look at the care homes, they would make those decisions. But the property and finance attorneys are the people who will be able to fund and pay for those care fees if that's what's provided. So 2 extremely useful documents. Your will is an extremely useful document, but if your property and financial affairs have gone to rack and ruin because nobody is managing them for the years before your death, there may not be anything to leave to your beneficiaries. So when we talk to people about wills, we also want to highlight the importance of looking at lasting powers of attorney. Now, if somebody has lost capacity and they don't have lasting powers of attorney in place, then there is the opportunity to make an application to the Court of Protection to be appointed as somebody's court-appointed deputy. The advantage of this is that somebody is still able then to manage your financial affairs for you. The disadvantage is that the person who makes the application to manage your financial affairs may not be the person that you would want to do that. The disadvantage is that it's much more expensive to go to the Court of Protection to be appointed as a deputy. It's more onerous for the person who is appointed as a deputy. There are annual reports they have to complete. They are governed by the Court of Protection, who may want to look at their records, who may want to come and meet them and talk to you. And the time scale for being appointed as somebody's deputy can be anywhere up to a year. It is complicated, it takes a lot of time, and nothing can be done within that year. If you want to make decisions regarding somebody's health and welfare, the Court of Protection does not want to appoint you as a general deputy for those decisions. Instead, they say that each decision is specific and each decision must be applied for separately. Again, this increases the costs of making those decisions, but also the timescales of making them. So if you are able to do so when you're thinking about making a will, you should also think about making lasting powers of attorney, both for your property and finance and for your health and welfare. They are separate documents, so if you feel you don't want to particularly think about health and welfare, you can make property and financial affairs lasting power of attorney. Thank you.
Thank you, Richard and Belinda, for explaining things so well. I'm always so impressed at how clear it always is. We've got time now for the question and answer session. If your question doesn't get answered in the time that we have, or maybe you have a more personal question, we would invite you to get in touch with Crombie Wilkinson directly, and I will forward you their email details in the email that I send out tomorrow. So just to get started, I'd like to start with the first question from Peter. Peter says his wife is Brazilian and he's British. They were married in the UK but live in Brazil. In the event of death does Brazilian or UK rule? Who would like to answer that one?
Nobody.
Belinda, are you going to have a go or shall I?
I'll start it off, but please
Okay.
begin, Richard.
Yeah.
If the majority of the assets of the person who dies are in Brazil, then it is likely that Brazilian law will take effect. You can make a will which says that English law takes effect, and people sometimes do that. If you have assets in both countries, ideally you should make a will that covers your assets in each country. Two wills that don't cancel each other out, but that deal with those assets specifically in that country. The laws of estates are often very different in different countries around the world, and it is often very much easier if your English will deals with your English assets and your Brazilian will deals with your Brazilian assets. In terms of inheritance tax, if you are a British citizen, Peter, it may, and you have assets still in the UK, it may be that you are treated as still being domiciled in the UK for inheritance tax purposes. And on your death, it may be treated that your worldwide assets come under the UK inheritance tax regime. This is probably bigger than the scope of what I'm saying, but certainly that's something to take, you know, quite detailed advice from. Most likely a solicitor or lawyer who is versed in the rules of both countries. But what we would normally recommend to somebody, if you have assets in both countries, is two separate wills that deal with those assets separately.
Thank you.
Yeah, I think that's very much the case. This thing called domicility tends to dominate the debate, and it's a bit of a strange concept because it's different to nationality. It is that concept of identity with a country. I think it's very important to understand how an estate or how assets devolve in both jurisdictions, because you could land up with some fairly weird consequences if the law in Brazil is a very different law to the law in the UK. And also to look very carefully what the tax consequences are likely to be. There is normally a saving grace when it comes to tax, in as much as there are normally agreements between countries that if you're taxed on an asset in one country, you're not taxed on the same asset again in the other country. But I think, as Belinda says, if you can find a solicitor with good knowledge of both English and Brazilian probate law, that would serve you the best.
Thank you. A question from Tim. In a nil rate band discretionary trust, is the nil rate the income tax or the inheritance tax rate?
No, well, the nil rate applies to inheritance tax. It's a bit of a strange name. Think of the nil rate band as being a personal allowance. Strictly speaking, it's not a personal allowance, but it is a band of which is taxed at 0%, and hence its name. But it's completely separate and distinct from income tax.
Thank you. From another question. Can a will leave instructions that part of my estate be sold at a specialist auction and the funds passed to someone or placed in a trust?
Yes, and this is similar to what Richard touched upon when he touched upon different executors to manage different parts of your estate. So yes, so if you have some specialist items, it may be that your executors need more guidance as to where those items pass or as to what happens to those. Yes, that can be included in your will. You could include it in a side letter. And it may be that you do have different executors that you wish to specifically deal with those assets and then place them into a trust. So yes, the answer is yes.
Excellent. Catherine would like to know, do the same intestacy laws apply in Scotland?
The Scottish legal system is a very different legal system to the English one. Its origins are very different. And I can't give a categoric answer to this, but I suspect it will be a different system. I don't know whether Belinda knows.
No, I don't, but it is a very different probate system in Scotland.
Okay, good to know. Tim would like to know, can gifts to charities in a will be gift aided?
Gift aid relates to income tax, not to inheritance tax. So if you make the lifetime gift of £100, let's not have £100, of £100,000, you'd have to have a huge income, wouldn't you? At least potentially, the gift aid could be a colossal sum, and similarly, if you have the income to support it, and you're paying marginal rate tax, you can take the benefit on your tax return in that respect. The significant thing is, if you've made that large gift to charity in your lifetime, it won't be clawed back into your estate if you die within the 7-year period we talked about. It is exempt from that.
Thank you. Another charity question. Would donating items such as artworks to a gallery that is a charitable trust be able to offset some inheritance tax?
Yep. If it's, if the picture's worth £100,000 and you give it to the Tate, then that 100,000 as such will be exempt from the inheritance tax point of view. Yeah.
Excellent. Sheila would like to know, could you please enlarge on what you said about inheritance tax implications of owning a business, not an agricultural asset? Does this affect capital gains too?
It is business property which carries a significant relief. I can't tell you precisely what that relief is at the moment. It relates to property itself. So far as capital gains tax is concerned, one of the advantages as such is that when you die, any capital gains liability is wiped out. So, for instance, be it business property or domestic property or an investment, you make I buy a house for £10,000. When I come to die, it's worth £100,000. I've got a capital gain of £90,000. If I were alive, that £90,000 would come into taxation. From a capital gains point of view, to use the technical term, there is free uplift at death. And you might say, well, why is that the case? And the answer is comparatively straightforward. If it weren't the case, effectively, there would be double taxation, because you'd be paying capital gains tax on the value of the gain, and you'd be paying inheritance tax on the value of the asset. And there is something of a convention, and I don't say it is entirely complied with, because it isn't, but there is a broad convention that you don't have double taxation.
Okay. Further question, can my daughter who lives in Australia be my executor and vice versa?
Are you coming in on this one?
Yes, sorry. Yes, they can be your executor. There may be difficulties in terms of some of the paperwork that needs signing, in terms of, because it's likely that if you pass away, your daughter will come over, but the course of probate is not always necessarily very quick, and therefore there may be difficulties with documents and signing, etc. It would be useful to have someone else as well, someone in the UK, but yes, they certainly can act as an executor. That's not a problem at all.
Brilliant, thank you.
I think, sorry, if I may, just as a side issue, not all executors have to take out the grant of probate. So it's perfectly feasible for you to have a mixture of family, friends, perhaps professional. So you've got a little bit of a selection there. You shouldn't have more than 4 executors. But depending on the circumstances, it might be that somebody takes the grant out, and the terminology is that power is reserved to other people to take out a grant as well. So that is, it gives people flexibility when they're trying to organise their affairs.
Thank you. Final question. I am currently a joint executor with a solicitor's firm, not Crombie Wilkinson. On the advice of the solicitor, inheritance tax was paid up front. All monies above 325,000 have been left to charities, including the University of York for a scholarship. Thank you. It's very kind of you. Now, nearly 3 years on, the solicitors is still trying to claim back the inheritance tax. Of course, this is very frustrating. The only people benefiting are solicitors, who are charging hundreds of pounds each for chasing HMRC. Would you advise others not to pay inheritance tax up front in such cases?
Well, the starting point is that before you can get the grant of probate, you've got to pay the inheritance tax. So it's not a question that you have any choice on the matter. Obviously, it's difficult to comment without knowing the full facts and circumstances. But when you're working out what the tax liability of the estate is, you should be taking into account the fact that the giving is to charity, and you should be doing an accurate calculation of the inheritance tax, with a few exceptions I'll come on to in a couple of minutes. Therefore, yes, I am a little puzzled as to why the tax was paid. Once you have paid tax to HMRC, getting it back again, we all know, is incredibly difficult and long-winded. The only slight consolation is that they normally pay you a sum of money in lieu of interest. Now, the sort of situation which arises is to claiming a refund as such, or paying additional, is if you've done valuations on estimates. So, for instance, you estimate the value of a property is £300,000, and as such you pay tax accordingly. The property is sold; it only makes £250,000. Therefore, you've overpaid the tax of 40% of £50,000, £20,000. So you claim the difference back. Conversely, that £300,000 house sells for £350,000. You find yourself having to pay an additional £20,000. So if you are dealing on estimates or valuations, let's put it that way, then you can anticipate that you will have a degree of adjustment. I don't know if Belinda's got anything more to say.
No, not really. Yeah, I'm a little bit baffled as to why inheritance tax was paid, if it's going to charities. But yes, I equally am having a lot of difficulty trying to get some money out of HM Revenue and Customs at the moment, and that is for a reason, as Richard pointed out, that an asset sold for less than its value. We paid the tax on the value we were given at the time, and now we're trying to get it back. They're just slow. They're just very slow, and there's not enough people that work there, and it does just involve lots of telephone calls until somebody gives in and deals with the paperwork that you've sent.
Thank you. Right, well, I think that's the end of our session. Thank you both so much. To let everybody know, we hold this session twice a year. Next one will be in January 2025, and you're very welcome to join us yet again. If you've got any more questions, feel free to email me or include them in the post-event survey, which will magically appear after you've exited the Zoom. It only takes a few minutes to complete, and we'd really appreciate your feedback. I'm also pleased to let you know that Crombie Wilkinson have generously offered a 25% discount on their will writing services, and I'll send you details of that in the follow-up email. I'll also send you a copy of this recording so you can re-watch it at some other point in the future. And if you're interested, please do get in touch with Crombie Wilkinson about your circumstances and let them know that you come via the University of York. On behalf again of the Office of Philanthropic Partnerships and Alumni, I'd like to thank Richard, Belinda and Laura and all of you, friends, staff and alumni of the University of York for being here today. Enjoy the rest of your evening and I hope to see you again soon. Bye.
Bye.
Goodbye.
Bye.